Hello.
Hi.
Hi. I'm sorry for us. We were intending to get you on the docket last week, but there were some issues. So I'm sorry for that.
Oh, that's all right.
All right. Court is calling 2024 CR 2208, State of Texas versus Samoya Lewis. Could I have parties announced for the record for the state?
Jason, go ahead.
Defense?
Here's something viewers might not realize. Even before a case starts, courtroom delays can tell a story. A scheduling issue might sound minor, but for defendants waiting anxiously, it's a nerve-wracking limbo. That small apology from the judge, it actually sets the tone, calm, human, and professional.
Your Honor, good morning. Frankie Sandoval on behalf of Ms. Lewis.
And are you Miss Lewis?
Yes, ma'am.
And how do you pronounce your first name?
Amoya.
Oh, okay. Counsel, have you received all the discovery? Did you review it with your client?
I have, Your Honor.
Court will find the state is in compliance with discovery. Ms. Lewis, I'm showing you what's entitled application. Okay, sure. Just give us 1 second.
Okay.
It's nice to know it's not only my software that gets glitchy.
All right, no problem. Showing you what is entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Does Ms. Lewis have priors?
Your Honor, not that I'm aware of.
Do you have any prior convictions?
No, ma'am.
Is this your first case?
Yes, ma'am.
All right. Could I have attorney's approach?
Thank you, Judge.
Now, this is key. The judge's question about prior convictions isn't casual. It affects everything from sentencing options to eligibility for deferred adjudication. Basically, if this is her first offense, the court can choose mercy over punishment, a second chance instead of a record.
All right. I'm going to show you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? It's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you.
Listen closely here. This section is a masterclass in courtroom procedure. The judge isn't just reading off a script. She's making sure the defendant truly understands what giving up her rights means. If Lewis says yes here but later claims confusion, this transcript becomes a court shield. Every yes, ma'am is legally bulletproof.
And you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Okay.
Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any, just 1 second. Counsel, has your client been able to provide you with any defenses to this offense?
We have discussed possible defenses. Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Judge.
Ms. Lewis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine to be probated. The state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the agreement. State is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 100 hours of community service restitution, and a referral to felony drug court. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. Say exhibit number 1 with all its attachments.
No objection, Judge.
All right, state, you may continue to confer. Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And
Yes.
did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
In the interest of justice, we would ask so, Judge, so that the TAP evaluation can commence as soon as practical.
All right, anything you wish to say on behalf of your client?
Your Honor, Ms. Lewis presents herself here. She's been a pleasure to work with, and once we went over the facts of the case and her options, she accepted responsibility.
This is where it gets emotional. The judge isn't just checking boxes. She's probing into Lewis's life, her family, her mental health, and her stability. Judges often use this moment to gauge who they're sentencing, not just what they did. Notice the empathy. She's balancing justice with rehabilitation.
And wishes to seek assistance so she can start putting this behind her.
All right, Ms. Lewis, do you have any support system?
Yes, ma'am.
Who would that be?
My godmother.
Okay. And where are your mom, your dad?
Currently in California.
Okay. So how did you end up in San Antonio?
My mom brought me here, and just to finish high school.
Okay. And who did she bring you here to finish high school with?
And just herself.
Okay. Why?
She had just exited the military,
Mhm.
and wanted to find a place to station, and she was choosing here.
All right. And when's the last time you had contact with your mom?
About sometime last month.
Okay. And have you ever had a mental health diagnosis for anything?
Yes.
What for?
Bipolar disorder.
Anything else?
And psychosis.
Okay. Do you have any children?
No.
How old are you?
27.
How far did you go in school?
High school.
You graduated?
Yeah.
And have you ever had any employment since high school?
Yeah.
Doing what?
Working at a chicken processing unit.
Okay. All right. So when did you start using drugs?
Just recently. Sometime last month.
All right. This is what the court is going to do. Court is going to sentence you to a $500 fine. That would be probated. 2 years deferred adjudication. A referral to felony drug court while in custody.
Big moment right here. The judge grants deferred adjudication. That's huge. It means Lewis avoids conviction if she completes probation successfully. In simple terms, she's walking out with hope, not handcuffs. But it's also a warning, one misstep, and that deferred sentence becomes a felony record.
Because it's Monday, they should be able to get to you this week. And even though, Michael, if you could move out of the line of sight of probation. And even though they may be full, they're about to have a graduation, so there may be some openings, okay?
Okay.
There's to be regular reporting by Zoom or in person, regular random UAs, field visits, one time per month until in treatment. TAP evaluation in custody. MIC evaluation out of custody.
Damn!
Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. A referral to Center for Healthcare Services. If she's in felony drug court, they'll take care of that. Probation, in 90 sober meetings in 90 days. Probation, is there anything, y'all need to get out of the line of sight of probation. All right, probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. So both defense counsel and the state have told me that you've had some criminal trespass issues in the past.
Uh-huh.
If you are homeless, let probation know, because they'll be able to give you some resources that can find a place for you to stay. But you cannot be picking up criminal trespasses. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
No, ma'am.
All right. In this court, communication is key. If there's an issue, pick up the phone, call your probation officer. If you feel as though they're not addressing it, you can always come back to this court, okay?
Okay.
All right. Good luck to you.
And this is why courtroom human moments matter. The judge's last words. Communication is key. Might sound like common sense, but in probation cases, it's survival advice. One missed call or missed meeting could undo everything. This isn't just legal talk, it's a lifeline.
To you.
Thank you.
And
Welcome.
in that regard, would the court happen to have a card so I could give to Ms. Lewis?